I see Mr. Florio has decided to grace us with his presence. Good morning,
Good,
sir. How are you?
good morning, Your Honor. How are you doing, sir?
I'm doing well. I see
Boy, stand
Mr.
up.
Florio has decided to grace us with his presence. Sorry. Good morning, sir. How are you?
Good morning, Your Honor.
I forget. I gotta shut that down. I've been working late into the night, a lot of past couple days, so I'm kind of tired, so I'm moving slowly. So who are you representing today, Mr. Florio?
Yes, yes, sir, Judge. I represent Mr. Joseph Borley.
You have the right to have the assistance of your attorney at all stages of these proceedings.
Miss Trammell? Miss Trammell.
Do you understand those rights?
I have no idea who that person is, not yet, but we'll try to figure it out. Deputies, may we bring up Mr. Borley and Mr. Florio? Are you willing to waive my spiel?
Yes, sir, you are. Oh, yes, sir, I am. I apologize, Judge. Yes, sir, I am.
No. So I have set bond for Mr. Borley, currently in the amount of $20,000. But as you know, I will listen to you about this case and your client as it relates to bond.
Yes, sir, Judge. I appreciate that. Your Honor, Mr. Borley is 58 years old. He lives in Morrow. He's the owner of the electrical company, which is a Jonesboro-based corporation. He's the sole employee of the company, but he works by trade as an electrician. He's lived here in the local Metro Atlanta area in the Clayton County for 35 years. He has one son who's 29 years old. He's lived in Morrow specifically for 21 years, Your Honor. We understand the nature of what we were charged with in this offense. What I've been told and what I believe is that how law enforcement came to become familiar with Mr. Borley, we're not certain. But I believe that he's a collector. He's a collector of antiques. He's a collector of things of that nature. And any allegation that he would have possessed any sort of explosives or things of that nature would have been purely for hobby purposes. I've had an opportunity to speak with some of his family. We believe that the items that may have been located by law enforcement are not even, they're relics. But they're not something that would have even been able to have been detonated, even if that was an intent. They're purely historical artifacts that he collects because that's his interest in antique things and historical items. I don't believe, from speaking with his family, I don't believe he has any prior felony convictions. Obviously, I don't have the benefit of having reviewed his GCIC myself, but I don't believe he's a convicted felon with any prior felony convictions. For those reasons, Your Honor, we would ask that bond be set in an amount of $10,000. I think it respects the allegations against us, but based upon the allegations, we believe that he's a good candidate for bond and a reasonable bond. The only question is how much will a bonding company make off of him? But in any event, based off what the court does this morning, there would be a bond and he would be supervised by a bonding company.
Well, it does not appear that there's an allegation that this device was used in an offensive manner against any person. So that's where I start with it. He does have, I believe, 15 cycles, and it's mostly been like misdemeanor kind of stuff. I think there was an arrest for aggravated assault, but I don't believe there is a conviction for that. So I would be willing to reduce the bond to $10,000.
Thank you, Your Honor.
You're welcome. And I don't know, of course, I don't know everything that's going on, but I'm happy that he's hired a lawyer that can at least advise him as to how to move forward. And Mr. Borley, you've made a wise decision in hiring the lawyer that you've hired. And my advice to you would be to listen to your lawyer as you move forward. So bond is going to be set at $10,000. He's going to have a preliminary hearing date set for January 4th. But that date, of course, will be waived upon his bonding out, and he'll receive a new court date in the mail. Is there anything else, Mr. Florio, on this case?
No, Your Honor, I've spoken with his family, and I believe that we'll be able to make bond today.
Okay. Mr. Borley, stay in contact with your lawyer. You're free to go back, sir.
Thank you.
Okay. All right. And you're free to go. Mr. Florio, it's great seeing you.
Thank you, Judge. It's good to see you as always. Take care, and if I don't see you before, have a Merry Christmas, sir.
You too.
Thank you.
Okay. So there's a Brittany Trammell, and it says for Mathis. And I don't know what that means. Could you unmute yourself? And
That's for the female side.
okay. Okay.
Deputy King. Go ahead.
Where's I mean, if it's a lawyer that's here to try to deal with their client's case, I'd be happy to deal with it. But
That's for you. That's your family.
okay.
That's your family. Your last name Mathis, right?
Yeah, my last name Mathis.
Okay, who is that to you?
I don't know if that's the lawyer that my brother got for me or my
It's-
mother. I don't know. But I know it was a lawyer supposed to be at court. They told my lawyer to be at court.
Okay.
Okay, ma'am, could you unmute yourself and identify yourself so we can resolve your matter and move on? You're still muted.
I'm sorry, Your Honor. Were you talking to me?
Are you the Brittany Trammell for Mathis?
Yes, Your Honor. I'm sorry. I was in Judge Cowan's courtroom. So I was in the midst of doing the plea. I couldn't say anything. But yes, sir.
Okay, ma'am. I try to deal with lawyers first and move on. If you want to be dealt with last, I can deal with you last. What's your preference?
No, I can wait as long as it's the court need. I was apologizing to you. I was in Judge Cowan's courtroom.
I
I'm sorry.
understand.
I'm not sure what answer you want me to give you today.
Ma'am, I want you to give me a truthful answer. That's all I require. The question that we have currently, do you want me to deal with your client now, or do you want me to deal with your client later? I will do whatever is your choice.
I would like to address this fund this morning, Judge, right now.
Well, ma'am, we're going to deal with it this morning. The question was, do you want to deal with it now?
I said it right now, Judge. I
Okay.
literally said right now at the end of my
Oh,
sentence.
what I heard was this morning.
I said this morning, now if possible, Judge.
Okay. I'm here to serve you, ma'am. And all I can do is ask direct questions. And all I expect is a direct answer to whatever question I give. So let's deal with Mr. Mathis. Will you be willing to waive the normal spiel that I give to everyone about their rights?
I'm not sure the benefit of us waiving it. I would be willing if, are you planning on setting a bond this morning, Judge?
I have set a bond.
Okay. Yes, Your Honor, we can waive the beginning conversation.
Okay. So, and your last name is Trammell?
Trammell,
I'm sorry,
Trammell.
Trammell. Okay, I believe everybody deserves respect of having their name pronounced correctly. So that's why if I'm unsure, I will ask. Attorney Trammell, your client is charged with 2 counts of forgery in the 3rd degree. I've initially set a bond at $10,000 for each charge. However, I will listen to you as to anything you want to say about your client in this case.
Thank you, Judge. Judge, thank you for setting a bond initially. I appreciate that. For Mr. Mathis, I don't believe that he's ever been convicted of a felony charge. This was retained on this last night. I am hoping for a reduction. Right now, I am doing this pro bono, I'll be honest. And so I just want to help him out. For the last couple of months, I know that he has been on a good path. I met his godmother, and I worked with her for a while on a case. And so I know for sure that he's been on a good path for the last several months. He's been in the house. I am asking if you would consider a lower bond. They are a little strapped for funds right now. If that's, they have ties to the community. They live in Clayton County, Judge. And so that's all I would be asking you to consider. He is involved in sports, and I don't think that, I think that this is a continuation of what initially was being investigated on.
Okay. It appears he does not have an extensive criminal history. When I was looking at the allegation, the reason I initially set the bond in the manner that I said it is that the allegation is that there was $7,550 taken in one check, and that there is $11,550 taken in another check. And I understand that those are just mere allegations. I'll tell you what, I will reduce the bond to 5,000 on each count. So it'll be a total bond of $10,000. He's going to have a preliminary hearing date, and you're muted.
I think it was initially, you had set it at 10,000, so you're going to keep it at 10,000, Judge?
Well, it was 10,000 for each count.
Oh,
So,
okay, I understand.
So it's 20,000 total. I reduced it to 10,000 total.
I got you, Judge. I'm sorry about that.
No problem. He's going to have a preliminary hearing date set for January 4th. If he does not make bond, if he makes bond, that date will get waived and he'll receive a new court date in the mail. Do you have any other questions for me?
Just one more. Do you know the time on January 4th? I'm pretty sure it'll probably be on the online inquiry.
It'll be Zoom. It'll be 8:30 in the morning. And so if he is unable to post a bond, then that date will be set.
Okay, thank you so much. I appreciate it.
And no, ma'am. Thank you. You're free to go. And Mr. Mathis is free to go back.
Thank you so much. I appreciate it.
Okay, have a good day.
You too, sir.
So let's start with just to bringing in everybody else. So for everyone else, this is your, I think we're gonna need the lady side to come back on also. Okay. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing, but should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you're in jail. If you violate the court's order, your bond will be revoked and you can remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person would not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you're currently on active probation, this court is not authorized to set bond at this time. Whether bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you speak to a lawyer first if you're unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You receive notice at the address you give of your next court date. Lastly, I need everyone to raise your right hand for me, please. Do you swear affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God?
Yes.
Okay, let's begin on the ladies' side with Miss Hadid or Haddad. Okay, ma'am, you're charged with one count of battery and one count of cruelty to children in the first degree. The cruelty to children in the first degree is a felony offense. I'm setting the bond at $5,000 for each. There's going to be a stay away provision on this bond to stay away from Khadijah Tourney, Tourey. Do you understand that, ma'am?
Yes, sir.
Your preliminary hearing date is going to be set for January 4th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Okay. I'm sorry. I got to get myself organized. Are you currently working, ma'am?
Yes, Your Honor.
About how much do you make per hour?
16, 10.
I'm sorry.
16, 10. 16 out of 18 cents.
Okay. I'm going to find that you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, Your Honor.
Okay, you're free to go back.
Okay.
Miss Howard. Miss Howard, ma'am, you're charged with one count of cruelty to children in the third degree. That's a misdemeanor. Bond is going to be set at $3,000. And you're charged with one count of family violence battery. Bond is going to be set at $5,000. There's going to be a stay away provision on this bond to stay away from Kahari Howard and Kamari Howard. And I know these are your children, but do you understand that, ma'am?
Yes, Your Honor.
Your preliminary hearing date is going to be set for January 3rd at 8:30 in the morning. That date will get waived upon your bonding out, and you receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, ma'am. You're free to go back. Miss Park. Give me 1 second, Miss Park. Miss Park, ma'am, you charged one count of simple battery. I've assessed or placed a $4,000 bond on this count. This is a misdemeanor offense. There's going to be a stay away provision to stay away from a Deshaun Luckett. Do you understand that, ma'am?
Yeah.
Your preliminary hearing date is going to be set for January 3rd. The date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. Are you currently working, ma'am?
Not right now.
Okay. I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, ma'am. You're free to go back. Miss, do we still have Miss Park?
No, sir.
Okay. let's move on to Miss Simmons. Or I'm sorry, Miss Saldana. I'm sorry, Miss Simmons. Miss Saldana, ma'am, you're charged with 1 count of simple assault, family violence. This misdemeanor offense bond is going to be set at $4,000. There's going to be a stay away provision on this bond, a stay away from a Margie Rivera. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for January 3rd at 8:30 in the morning. The date will get waived upon your bonding out, and you will receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. Are you currently working, ma'am?
Yes.
About how much you make per hour?
1570.
Okay, ma'am. You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, I don't. Thank you.
Okay. All right, ma'am. You're free to go back. Now, Miss Simmons. Miss Simmons, ma'am, you're charged with 1 count of criminal trespass. Bond is going to be set at $3,000. This is a misdemeanor offense. There's going to be a stay away provision on this bond to stay away from Darrell or Darrell Holmes, Holmes. Do you understand that, ma'am?
Yes, sir.
Your preliminary hearing date is going to be set for January 3rd at 8:30 in the morning. That date will get waived upon you bonding out, and you will receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer, ma'am?
Yes, sir.
Okay. I'm going to find that you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, ma'am, you're free to go back. Miss Smith. Give me 1 second, Miss Smith. Okay, Miss Smith, ma'am, you're charged with looks like 3 or 4 misdemeanor offenses. The first one is hit and run, leaving the scene of an accident. Bond is going to be set at $3,000. The second one is failure to yield the right of way when turning left. Bond is going to set at $500. Driving a vehicle without a valid license, bond is going to be set at $1,000. And a red light violation, which is essentially commonly known as running a red light, bond is going to be set at $500. You're going to have a preliminary hearing date set for January 3rd at 8:30 in the morning. That date will get waived upon your bonding out, and you receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, ma'am?
Not right now.
Okay. I'm going to find that you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, ma'am. You're free to go back. Miss Wimbush.
Good morning, Your Honor.
Good morning, Miss Wimbush, ma'am. You're charged with 1 count of aggravated assault with a deadly weapon. And it does not appear that the charges have all translated over to a bond sheet. I have I've denied bond on aggravated assault with a deadly weapon. But it did not appear that you had like a extensive criminal history. There's cruelty to children. that didn't make it over. Onto your bond, which I'm gonna have to fix. So this is what I'm gonna do, ma'am. I'm gonna set a bond at $20,000 for the aggravated assault with the deadly weapon, possession of a firearm or knife during the commission of a crime. I'm gonna set the bond at $5,000. Family violence battery, set a bond at $5,000. And there's going to be a stay away provision on this bond to stay away from a Craig Howard. Do you understand that, ma'am?
Yes, sir, I do.
Hold on. I want to make sure I address each charge. It's cruelty to children as a misdemeanor. Bond's going to be set at $3,000. Okay. I don't know why these charges didn't translate over into your pre-printed bond order. So when I get started in the morning, I print everything out. And the only charge that came over was the aggravated assault with a deadly weapon. But I've set bond on these offenses. And I placed a stay away provision. So I'm going to have to do a separate bond order. Your preliminary hearing date, ma'am, is going to be set for January 4th at 8:30 in the morning. That date will get waived upon your bonding out. You're going to have to stay away from Mr. Howard, because if you violate this order, you will be charged with aggravated stalking. Your bond will be revoked and you'll remain in jail until your trial. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir, I do, Your Honor.
Okay.
Thank you.
Ma'am, it's my duty. So I appreciate you saying thank you, but it is my duty to you. I'm going to find that you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, sir, Your Honor, I do. I would like to know if you could lower my bond. I make $11.50 an hour.
So I will consider that, ma'am, and I'm gonna have to look maybe a little bit deeper into this. The allegation is a serious one. Whenever someone is alleged to have discharged a firearm or use a knife in an offensive way, I take that seriously, because that's one step away from, I don't know, the injuries of Mr. Howard. And I'm not asking you to justify it or speak about it, because you need to speak to your lawyer first. but it's so quick to lead to the death of a human being. And if somebody's willing to do that, I take that seriously. So I will look into this, ma'am, because I have to do the paperwork to send everything back before anybody is able to bond out. So I promise that I will look into this, and I have to speak to my my assistant. But I'm willing to reduce it on the aggravated assault with a deadly weapon. The others I'm not. Now, I try to remain consistent with setting of bonds. But this is one where I can set it at $100,000. I can set it at $10,000. It's within my discretion. So I just want you to understand the allegations are serious, and I'm certain that you have your side to the story. And nope, and I'm not gonna ask you to tell me that. But I'm gonna look into it, and with an eye towards granting your request. Okay.
Yes, sir. So can you tell me the complete amount as of right now?
Right now, we're gonna take the aggravated assault out of it. Possession of firearm or knife during the commission or attempt to commit a felony, that was set at 5,000. The battery, that was set at 5,000. And I don't know why these didn't all make it onto the bond order. So I'm literally having to go through 20 pages as I'm telling to you. So cruelty to children, that was a misdemeanor. That was set at 3,000.
Excuse me, Your Honor.
Yes,
Are
ma'am.
are my charges the same? I have deadly weapon and then using the same charges?
No, I'm sorry. Can you say that again? You went out.
My charges, same thing, Your Honor. Simple battery, aggravated assault, and something with a deadly weapon. Why was I charged 3 times for the one incident that I did?
So the short answer to that question is that's what the legislature has decided. So if, and you asked a question, so please pay attention. Let's say I pull a gun out on you. That's either simple assault or aggravated assault. I pull the trigger. That's aggravated assault. I'm holding the gun. That's possession of a weapon during the commission of a crime. So these charges can stack up real quickly, and they're all considered separate offenses because there's a different element that makes the crime. So even though You may have done one thing. There are separate elements that you can be charged with as the crime unfolds. And that's, they don't consider those. I mean, and you get into the weeds when you're talking about issues of merger and how it relates as to punishment. So, and it's just a quick, just debriefer. You can be charged with all of this stuff, but at some point, the crimes, what they call merge, meaning there's a bigger offense and a smaller offense. And I did the smaller stuff, but the smaller stuff also is a part of the bigger stuff. So you may not be punished for the smaller stuff because it all goes up, and they call it merges into the bigger stuff. So essentially, I believe that's the question that you're asking, but it doesn't mean you can't be charged. For instance, if you're charged with a bigger crime, let's say that carries life, and a smaller crime that carries 5 years, you'd much rather be charged or convicted of the smaller crime that carries 5 years than the bigger crime that carries life. So all of that is why people need lawyers. They need to listen to their lawyers, and they need to follow the lawyer's advice. So is there any other question, Ms. Wimbush?
No, sir.
Okay, man. I wish you the best of luck. You're free to go back. Okay.
Your Honor, that's all the females.
Thank you. Let's move over to the males.
You ready to go? All right, gentlemen.
Is this Mr. Buckheiser?
Yes, sir.
Is it Heister?
Yes, sir. Like it's Buck and like heister, like you're pulling a heist. I think it's German. I believe it's German. You kind of got to spit it when you say it.
Well, yes, sir. Like I said before, I believe everybody deserves the right to have their name pronounced correctly.
Yes, sir.
So, sir, you're charged with 1 count of loitering or prowling. This is a misdemeanor offense. Bond is automatically set, which means it's set by schedule at $1,000. You're going to have a preliminary hearing date set for January 3rd at, 8:30 in the morning. The date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir. I was also told that I might be eligible for OR bond. Is that possible?
Well, hold on. Let me look at your history.
Okay.
But unfortunately, the way that it works is that my boss is the only person that can approve of an OR bond. And that means that you may have to stay in custody for another day just for me to be able to reach out to her and get her to consider this. And it doesn't mean that it's going to be granted. So,
okay, well, it's okay then. I'll just bond out to a company.
Okay.
Yes, sir.
And I'm looking at your criminal history. You don't have a bad criminal history, but you do have 3 cycles. And I know just from discussions with her is that it's considered like you're a college student that had a marijuana joint or something.
Yes, sir.
Okay.
That's pretty much it. Yes, sir.
Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir. If you don't mind, I appreciate it.
Are you currently working?
Yes, sir. Applebee's.
Okay. I'm gonna find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir. How much did you say my bond was again?
It's $1,000.
Okay.
And that is the lowest amount. Through my understanding, that's the lowest amount that we can set where a bonding company will be willing to come in on the bond.
Gotcha. All right. Well, thank you, Your Honor.
You're welcome. You're free to go back, sir.
All right.
Just
Appreciate
take a
it.
seat in the back.
Mr. Chandler.
Gentlemen, please do.
How you doing, man?
Mr. Chandler, sir, you're charged with one count of failing to stop or yield at a stop sign, which is commonly known as running a stop sign. Bond is set at $500. You're also charged with the simple possession of a controlled substance. Bond is going to be set at $5,000.
Yes, sir.
Because of the felony offense, your preliminary hearing date will be set for January 4th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify. I'm going to appoint a lawyer to represent you.
Yes, sir.
Do you have any questions for me?
I was wondering, is that the lowest you can go? I am contracted right now, so I can actually make the bond to get out.
Well, to answer the question, yes, that is the lowest I can go.
Okay, thank you.
Okay. All right, sir.
You have a good day, young.
You too. Mr. Dasher. Mr. Dasher, sir, you charged one count of criminal damage to property in the second degree. This is a felony offense. Bond is going to be set at $5,000. There's going to be a stay away provision on the bond to stay away from a Michelle Dasher. Do you understand that?
Yes, but the property is mine. It's my property.
We'll get to that in a second. But I just need you to understand that right now there's a stay away provision for you to stay away from her.
Okay.
Your preliminary hearing date is set for January 4th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Are you currently working, Mr. Dash?
Yes.
About how much you make per hour?
13, like 12.
Okay. I'm gonna find that you qualify, sir. I'm going to appoint a lawyer to represent you. Now, to get back to the issue that you raised. As far as the court is concerned, people are identified, and the labels mean something. Right now, she's the alleged victim, you're the alleged perpetrator, and they're both are alleged because you're not proven. You stand here as an innocent person. The allegation is that you used a large rock to break out the windows of this person's car. That's the allegation. You have not been convicted of that. Whatever happened that brought you before me is something that we don't want to happen again. Okay.
Yes, sir.
We just don't have the resources to put law enforcement officers at everybody's house to referee fights between adults or disagreements. If you have allowed this person, is this your wife?
She's family.
She's family. And you're saying she lives with you?
Yes.
Okay.
Her last name is Thornton. My last name is Dasher. Everything is in my name.
Okay. So I'm just being straight up with you. Okay. Allowing her to live with you and then allegedly putting a brick through her windows or a rock through her windows. Those are two bad choices. And those are two bad choices that you made.
I can be able to stay away from her.
That's fine. And this does not mean you cannot go back to that property. If she is still living at that property, you cannot be in that property with her.
Okay, but I still have to go. I still have to go to work though. Like, is there any way that I can try to get like a signature on? Because I still have to go to work. She can still have my property and still use it, but I still have to go to work though.
Mr. Dasher, you're asking me to essentially co-sign on behavior that you allegedly made. And again, these are all allegations, but the answer to your question directly is no. You cannot get an aura bond. If you are my son, family member, someone, I would say, hey, dude, if a person makes you that angry, that person don't need to be around you. And you cannot make poor decisions and then ask for someone to co-sign on those poor decisions. Okay? So I can appoint you a lawyer and I can move this along, but I can't do what you're asking. Okay?
Okay.
All right, sir. You're free to go back.
Your Honor.
Mr. Yes, sir.
Can you give me 1 second? I want to explain something real quick because I know
Yes,
they keep
sir.
asking about it.
Yes, sir.
Your Honor, we're ready to go again.
Yes, sir. Mr. Is it Esprit?
Esprit, yes, sir.
Esprit, sir, you charged 1 count of family violence, battery bond is set at $5,000. This is a misdemeanor offense. There's going to be a stay away provision on this bond, a stay away from a Denise Williams. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is going to be set for January 3rd at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. You want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, sir, I'm going to find that you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Yes, sir.
No
I'm
questions.
sorry.
No questions.
Okay, all right, sir. You're free to go back.
Okay, thank you.
Mr. Everett,
Are we seeing him?
Judge, we're getting Miss Everett right now.
thank you. Mr. Everett, sir.
Good morning, sir. I was here. They brought me here at the model. I was at the model. Hold on, you gotta do that, bro. Good morning, Your Honor. I had to give you my ticket. I'm going out of town to get some help today. I'm all right. I'm doing the right thing. I'm going to Gwinnett County to get the help that I need today. And yeah, good. Thank you for the OR bond, sir. And I've still been working today. And I'm going. Thank you, sir. I'm going to go to work today. Going to work. I work. I'm going to
So, Mr. Everett, sir, you're charged with one count of essentially not paying for a not paying to get onto the MARTA system.
Yeah.
And I've set the bond at $1,000 for
He
that.
said the OR bond. That's it, the OR bond. Thank you, sir. So I get to work. He said they got down. I got down, go to work with him. I work. I'm going back to OR bond. I'm going to
I understand. I understand. Mr. Everett,
my
you're
first
also,
time. I got my social. My first time ever being locked up before, sir. Your Honor.
I understand. Take a breath, Mr.
Yes,
Everett, and just listen to me.
Yeah.
You're charged with one count of sexual battery, and this is a serious offense.
No, he said something about it. A purse. Not a purse. It was a purse. I'm not no such a great purse. I promise you. Nah, I promise you. The purse, they said I lost a purse. I said I'm not. That's why I'm not looking for my one similar battery to the mall, the train station, bro. The train station, no. You made the trains that I couldn't get with the money that I paid for.
So, Mr. Everett, the allegation is that you grabbed the behind of a female employee at the sheriff's department as you were going through the booking process, and that this is on camera. Okay. So that is a serious offense, and I'm setting the bond at $10,000 for that.
I ain't grabbing it. I don't do that. I can't.
Mr. Everett, these are just allegations.
I ain't did nothing. I ain't doing set the purse. I set the purse. I'm here for one model, one misdemeanor. Okay, all right. Boom, that you can drop that off and talk to the lawyer in order to release.
I understand. I'm going to appoint a lawyer to represent you, sir. You're going to have a preliminary hearing date set for January 3rd. If you bond out, that date will get waived and you'll receive a new court date in the mail. So you are now free to go back, Mr. Everett.
Other one already showing out. Who's the other one?
Mr. Hansford, I believe, is going to be next.
Yes, sir.
Evening, Your Honor.
Good afternoon. We've just reached noon, sir. You're charged with one count of Possession of drug-related objects is a misdemeanor. Bond is going to be set at $1,500. You're charged with 2 counts of simple possession of a controlled substance. Bond is going to be set at $5,000 for each. You're charged with possession of a weapon during the commission of a crime. Bond is set at $5,000. And you're charged with driving a vehicle on a suspended license. Bond is going to be set at $1,500. Your preliminary hearing date is going to be set for January 4th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir, Your Honor.
Okay. Are you currently working, Mr. Hansford?
Sir.
Okay. I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, Your Honor, just to ask if it could be reduced, I'm gonna have to pay that money back to, okay, never mind, sir. Sorry, Your Honor.
Okay. And I'm going to deny that request. Mr. Harvey. Mr. Harvey, sir, you're charged with 1 count of simple possession of a controlled substance. I'm setting the bond at $5,000. That's a felony offense. You're also charged with 1 count of possession of a firearm during the commission of a felony. That is also a felony offense, and I'm setting the bond at $5,000. Your preliminary hearing date is going to be set for January 4th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, Mr. Harvey?
No, sir.
Okay. I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions?
No, sir. Could you repeat my bond for?
Yes, sir. It's a total bond of $10,000. It'll be a little bit higher because the sheriff's department is required to add fees to the bond. So there will be fees added on to the bond. Okay, sir, you're free to go back. Mr. Howell.
Good afternoon, sir.
Good afternoon, Mr. Howell. Sir, you're charged with 1 count of battery, and bond is going to be set at $5,000. You're also charged with 1 count of exploitation of a elderly person. Bond will be set at $5,000 for that. 1 count of obstructing an officer. Bond is going to be set at $3,000. There's going to be a stay away provision on this bond to stay away from I think it's Therese Mary Goodry. And I know that's I believe that's a relative.
Yes.
There's going to be a bond to stay away from that person. Do you understand that?
I understand that.
Your preliminary hearing date is going to be set for January 4th at 8:30 in the morning. And that date will get waived when you're bonding out, and you'll receive a new court date in the mail. The cruelty, called the exploitation or cruelty of an elderly person, is a felony offense. So you should be aware of that. Do you want me to see if you qualify for the appointment of a lawyer? Okay. I'm going to find that you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, sir, you're free to go back.
Thank you.
Mr. Humphreys. Mr. Humphreys, sir, you're charged with 1 count of battery. That's a misdemeanor offense. Bond's going to be set at $5,000. You're charged with 1 count of entering an automobile. That's a felony offense. Bond is going to be denied on that. You're also charged with 1 count of criminal trespass for purpose. Bond is going to be set at $5,000. And finally, you're charged with 1 count of robbery. and bond is going to be denied on that. There's going to be a stay away provision on this bond, stay away from a Monique Reddick. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is going to be set for January 4th at 8:30 in the morning. You're also going to have a bond hearing date set for January 6th at 8:30 in the morning.
May can I mention one thing, sir?
Yes, sir. In 1 second. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, Mr. Humphries?
Well, not anymore.
Okay. I'm going to appoint a lawyer to represent you. Now, what is it that you wanted to tell me?
Well, I wanted to state for the record that this is the second time that I have been lied on and accused by Monique Reddick, and it is proven facts in that this case has happened twice already. And I'm just trying to get this behind me. I haven't seen her in over 2 years, and I just want to move on with my life. But it is in record, and it's a statement of past case of what I'm on probation for, that she recanted her statement of this, because we were supposed to be getting married, and this case happened 2 years ago.
And it says the incident date is April 27th of 2021.
Yes, sir. And if you look where she has recanted her story, and we were supposed to get married, we were staying together and all that. So that's why I'm not understanding it. And all this is just because of domestic violence. Second time I've been lied on.
Well, sir, when you say all of this is just because of domestic violence,
Meaning, what I mean by that is that having an argument, and this is the second time she have called the police on me and made false allegations. It's proven facts. The statements in the last case, and that she recanted her story, facts that I have been lied on, and she have made false police reports.
what was the last case?
The last case was when she got locked up for child cruelty, battery, criminal trespassing, burglary, and everything has been proven that it belonged to me, that I stayed there, that we was a couple, and we was together, and we was fiancés. And I haven't seen her in 2 years now, that I have moved on, and I'm currently married to somebody else. I can't keep coming to jail for lies. And this is currently what that is. And it has happened, in this proven facts. And she has recanted her statement. Because I like to say is, the statement is there that she has done this before, recanted her statement, told the truth of everything that she said I allegedly did in the previous case, and came back and recanted the statement and told the truth, said I didn't do all that. And this is an ongoing case. This is another case that she has done it again.
Mr. Humphries, I'm going to ask you what may sound like a stupid question, but why were you still with her?
This might be the stupidest answer I can give you. Love, sir. Love.
You said love?
Yes, sir. Because when it happened, I thought we could have worked through it. But once I got out, I can't keep coming to jail, because if I don't want to be with you, and this be the first thing you use against me, it's my criminal history took away. And it is proven facts that she has done this before. And this is another case of it right now. I have had no problem with the law. I've been doing good. I just had a job. I just got to work. They ran my name, and that's why I'm back in front of you now, trying to plead my case. I moved on, sir. I left that problem alone.
I'm
The advocate, witness advocate, the DA that was on the case, he was contacted. You can look at statement. It says that we was an item whose fiance who was on the verge of getting married. I didn't want to get married no more. So here I am today seeing you for my stupid decision. And that's, I should have known, but I didn't.
I understand, and there's the way that things are written and the laws are written, I can't grant you a bond. On these.
I just wanted to be out there known that this has occurred before, and it is a written statement that she has recanted her story by putting these allegations out against me. And that I'm hearing, it's my life. It's my life.
It may be in your interest. I mean, I'm appointing the lawyer to represent you, but based upon what you said, assuming everything is true, it may be in your interest to pay for a lawyer to intervene, because I can't set the bond today, but it doesn't mean this attorney's office can't consent to a bond tomorrow.
Okay, thank you.
Okay.
All right, thank you.
All right, sir. You're free to go back. Mr. Jackson. Mr. Jackson, sir, you're charged with 2 misdemeanor offenses. One is criminal trespass. Bond is set at $3,000. The other charge is battery. Bond is set at $5,000. There's stay away provision on this bond to stay away from a Miriam White. Do you understand that, sir?
Yes, I understand that fully, sir.
Your preliminary hearing date is going to be set for January 3rd at 8:30 in the morning. That date will get waived upon you bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment?
Yes, I do. Yeah.
Are you currently working, Mr. Jackson?
Yes, I am, sir.
About how much? Excuse me, about how much do you make per month or per hour?
Currently, I make about $20 an hour. I work about 20 hours a week.
Okay, I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me, Mr. Jackson?
No, I do not, sir.
Okay, sir, you're free to go back.
Thank you.
Mr. Jenkins. Mr. Jenkins, I'm glad you made it back here from yesterday. I understand you had a hearing in another courtroom. You're charged with 2 counts of aggravated assault with a deadly weapon. There's going to be a $20,000 bond set on each of those offenses. There's going to be a stay away provision on this bond to stay away from beyond Walker. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for January 4th at 8:30. That date will get waived when you're bonding out, and you'll get a new court date in the mail. Do you have any questions?
No, sir.
Okay, you're free to go back. Mr. Gordon. Mr. Jordan, sir, you're charged with 1 count of aggravated assault by strangulation. Bond is going to be set at $20,000. You're charged with 1 count of battery, family violence. Bond is going to be set at $5,000. You're charged with 1 count of theft by taking as a misdemeanor. Bond is going to be set at $2,000. There's going to be a stay away provision on this bond to stay away from Yolanda Womble. Do you understand that, sir?
Sir.
Your preliminary hearing date is going to be set for January 4th at 8:30 in the morning. That date will be waived upon your bonding out. and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. I'm going to find that you do qualify, Mr. Jordan. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, sir, you're free to go back. Mr. Is it Kerry
Yes, sir.
Palomeri?
Yes, sir.
Sir, you're charged with one count of simple battery, family violence. Bond is going to be set at $4,000. This is a misdemeanor offense. There's going to be a stay away provision on this to stay away from Alexandra Calderon. Do you understand that, sir?
I understand that, sir.
Your preliminary hearing date is going to be set for January 3rd at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
Are you currently working?
No, yeah. I'm moving, so I'm just looking for a job. I got my interview today and I lost it.
Okay.
And I got my mom outside waiting to pay the bond.
Okay. I'm going to find that you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, sir. You're free to go back.
Thank you.
Mr. Magnum. Sir, you're charged with one count of criminal trespass. This is a misdemeanor offense. I've set the bond at $1,000. There's going to be a stay away provision on this bond for you not to return the 5883 Highway 85, also known as the Circle K. Do you understand that? Your preliminary hearing date is going to be set for January 3rd. The date will get waived upon your bonding out. You'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer? I'm going to appoint a lawyer to represent you, sir. Do you have any questions? Okay, sir, you're free to go back. Mr. Reed.
Yes,
Mr. Reed, sir, you're charged with one count of loitering or prowling. That's a misdemeanor offense. Bond's going to be set at $1,000. You're charged with one count of driving a vehicle on a suspended license. Bond is going to be set at $1,500. One count of misdemeanor possession of marijuana. Bond is set at $1,500. $1,500. One count of simple possession of a Schedule 1 substance, that's a felony. Bond is going to be set at $5,000. And one count of use of possession of drug-related objects, that's a misdemeanor. Bond is going to be set at $1,500. Because of the felony offense, you're going to have a preliminary hearing date set for January 4th at 8:30 in the morning. That date will be waived upon the bonding out, and you'll receive a new court date in the mail. Now, do you know what you want to do as it relates to a lawyer? Do you want me to see if you qualify?
Yes. And can you also give me the roundabout of how much the bond is?
Let's see. 3, 8, 10,500. Roughly. It's going to be a little higher than that, but 10,500. Okay.
Yes.
Are you currently working, Mr. Reed?
Yes.
About how much do you make per hour?
17.
Okay. I'm going to find that you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, sir, you're free to go back.
Thank you.
You're welcome. Mr. Salisbury. Mr. Salisbury, sir, you're charged with driving offenses. One is following too close, set at $500. The other one is driving a suspended license. Bond is set at $1,500. Your preliminary hearing date is going to be set for January 3rd. The date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer, Mr. Salisbury?
Yes, sir.
Are you currently working, sir?
Yes, sir.
About how much do you make per hour?
$22.50.
Okay. I'm going to find that you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
What about again for the total?
It's going to be 2,000 as the total that's been set, but it'll be a little bit higher when they add the fees to it. So it may be 2,500 or something like that.
Okay.
Okay. All right, sir. You're free to go back.
Thank you, sir.
You're welcome. Mr. Sharon.
Good afternoon, sir.
Good afternoon, Ms. Sharon. You charged one count of looks like it says drug-related object. Bond is going to be set at $1,500. 2 counts of misdemeanor, not misdemeanors, felonies, but simple possession. Bond is going to be set at $3,000 for each. 1 count of possession of firearm during the commission of a crime. Bond is going to be set at $5,000. 1 count of giving a false name, address, or date of birth. Bond is going to be set at $2,000. Your preliminary hearing date is going to be set for January 4th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer, Mr. Sharon?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Oh, okay. All right, sir. You're free to go back.
Just the total bond, sir. I'm sorry.
Oh, okay. I'm sorry. Looks like $14,500.
Thank you.
You're welcome. Mr. Walker. Mr. Walker, sir, you're charged with 1 count of simple possession of a controlled substance. That's a felony offense. Bond is going to be set at $3,000. 1 count of driving a vehicle with no insurance. Bond is going to be set at $1,000. 1 count of driving a vehicle too fast or conditions. Bond is going to be set at $500. 1 count of driving under the influence. Bond is going to be set at $5,000. 1 count of hit and run accident. Bond set at $3,000. And 1 count of driving a vehicle without proper insurance. Bond is going to be set at $1,000. Because of felony offense, we have a preliminary hearing date set for January 4th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. I'm going to find that you do qualify, Mr. Walker. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, sir. You're free to go back. Mr. Williams.
Yes, sir.
How are you, Mr. Williams? Sir, you're charged with 1 count of battery. This misdemeanor offense. Bond is going to be set at $5,000. There's going to be a stay away provision on this bond to stay away from a Sandra Copeland. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is going to be set for January 3rd at 8:30 in the morning. That date will get waived on your bonding out, and you receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Are you currently working, Mr. Williams?
I was. Once I get out, I have to see if I still have it.
Okay. I'm going to find that you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Oh, Your Honor.
Okay. All right, sir. You're free to go back.
Appreciate you. Have a good one.
You too.